This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about how an intentional act would defeat coverage on an excess or umbrella commercial liability policy covering employers' liability, and why in Texas an employer's liability coverage only covers accidental injury, and an intentional injury would take you out of the exclusive remedy of workers' compensation. In Graphic Packaging versus Everest National Insurance Company, the Superior Court of Delaware, in a decision rendered on May 8, 2023, dealt with a plaintiff who sought coverage under an employer's liability insurance policy for losses the plaintiff incurred litigating and settling a workplace injury action filed by its employee. The insurance policy provided coverage only for bodily injury by accident. In the underlying litigation, the employer faced a claim that it knowingly engaged in conduct that was substantially certain to injure its employee. The employer settled the underlying litigation shortly before trial, and the insurance company denied coverage for the settlement on the basis that the litigation involved a claim for intentional tortious conduct, rather than a claim for an accidental injury within the scope of the policy's coverage. Under settled Texas law, Texas workers' compensation law, when the employer commits an intentional act, the exclusive remedy does not apply. Accordingly, the only claim the employee brought in the underlying litigation was that the employer's conduct rose to the level of intentional tort. Plaintiff's Graphic Packaging, also known as GPHC, makes sustainable paper-based packaging solutions for a variety of food, beverage, food service, and other consumer products companies. GPHC's primary insurer, Arch Insurance Company, issued a workers' compensation and employer's liability policy to GPHC and Graphic called the Arch policy. The Arch policy contained a $1 million per occurrence limit and provided two separate coverages. In Part 1, the Arch policy insured Graphic's obligations under the state's workers' compensation laws. In Part 2, the Arch policy insured Graphic for employee injury claims outside of workers' compensation. Everest National provided a commercial umbrella liability policy to GPHC and its subsidiaries, including Graphic, the Everest policy, which contained a $25 million per occurrence coverage limit in excess of the Arch policy. The Arch policy, which Everest followed, included coverage for bodily injury intentionally caused or aggravated by Graphic. Mr. Compton, a Graphic employee, sustained an injury while working at a Graphic paper mill in Texas. During steam production, it was important that a sudden intense release of steam, known as a blowdown, occur. In July of 2018, a hole developed in the blowdown header, requiring placement of a temporary steel patch until the mill could be shut down for repairs. Graphic knew the safest way to repair the blowdown header was to shut down the production process, but Graphic instead ordered Mr. Crompton to manually perform the steel patch. When Mr. Crompton started the repair, he noticed hot water leaking from the hole in the header and told his supervisor he was concerned for his safety. Mr. Crompton returned to the blowdown header, and while he was working on the steel patch, because his employer ordered him to, a blowdown occurred, covering him in scalding steam that severely burned him. The Texas Workers' Compensation Act, the TWCA, controls the relationship and conduct between an employee who is injured in the course and scope of his employment and an employer who has workers' compensation insurance. When an employer commits an intentional act, a common law exception exists to the otherwise exclusive remedy created by the TWCA. Mr. Crompton and his wife sued Graphic in the Compton action, alleging the conduct of Graphic rises to the level of intentional tort. Specifically, Graphic had knowledge to a substantial certainty that its conduct would bring about harm to Crompton. Arch, as Graphic's primary insurer, defended Graphic in the Compton action. Arch offered to tender its $1 million employer's liability limit to Everest to use to attempt to settle the Crompton action, but Everest rejected Arch's tender because Everest continued to believe that no coverage existed for any liability Graphic may face in the pending suit. The parties in the Crompton action participated in a settlement conference. During that conference, the Cromptons reduced their demand, and Arch reiterated that its entire $1 million policy limit could be used by Everest and Graphic to settle the case. Everest refused to give Graphic authority to use any portion of the Everest policy to settle the Crompton action. The Cromptons accepted the mediator's proposal, and Graphic paid that portion of the settlement in excess of Arch's policy limit, and then filed a coverage action against Everest for failure to cover the Crompton action. The court concluded that it was clear, as a matter of law, that the Crompton action did not fall within the scope of Everest's coverage. Under the terms of the Everest policy, it was not entitled to any coverage. The Everest policy's insuring agreement, incorporated from the underlying Arch policy, states bodily injury caused by intentional tortious conduct is different from bodily injury caused by accident. Courts interpret the term accident in an insurance policy to mean an event which takes place without one's foresight or expectation or design. The controlling Texas law was that only a substantially certain intentional injury would have made Graphic liable in the Crompton action. The Cromptons alleged in their complaint that Graphic knew or believed its actions would injure Mr. Crompton. That claim does not and cannot be construed to fall within the policy's coverage for bodily injury by accident. The Cromptons could prevail only if they proved Graphic, through McCrite, intended to injure Mr. Crompton. At the time of the settlement, therefore, Graphic was facing only an intentional tort claim. Intentional torts fall outside the scope of the policy's coverage for accidental injury, and therefore the Cromptons' claim against Graphic did not fall within the Everest policy scope of coverage. In my opinion, since the only way the Cromptons could succeed is to prove that Graphic intended to harm Mr. Crompton, and as a result there was no possibility that Everest could owe indemnity to Graphic. Since Everest's policy followed form with the Arch policy, Graphic should have been happy that Arch offered up its limits, because I assume it believed that its workers' compensation obligation exceeded the $1 million it offered. The case was resolved in favor of Everest, and Graphic got no money to reimburse for its losses. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. At that URL, you'll have the opportunity to subscribe to the blog, and that would give you notice of every blog posting, usually 5 or 6 a week. And you can also subscribe to the rumble.com or the YouTube.com videos, and I'd appreciate it if you do, if you click on the like button on YouTube or the thumbs up button on Rumble.com. Thank you for your attention, and if you found these videos and or blog postings to be useful, please tell your friends and colleagues so that they can also subscribe. And if you wish further detailed information on insurance claims and insurance law, please consider subscribing for a very small fee to my Locals community or my Substack publications. Thank you again.